base my arguments on the basis of the articles which are laid down under the Constitution. First 2 days we have debated with regard to the Constitution and our dedication to the Constitution. Today's my bill solely rests upon the articles which are laid down under the Constitution, and we have not gone beyond even a single inch from the articles which are laid out all these provisions of law. I would like to take the House Article 142 of the Constitution. Article 142 of the Constitution, it clearly mandates that the judgments of the Supreme Courts, how it should be responded by the governments. It is very clear. Wait, please hear me. No, sir. Practically, that article, based on that article. (142) of the Constitution, the Supreme Court, in the exercise of its jurisdiction, may pass such decree or make such orders as is necessary for doing complete justice in any cause or matter pending before it, and any decree so passed or order so made shall be enforceable throughout the territory of India in such a manner as may be prescribed by or under any law made by the Parliament, and until the provision in that behalf so made in such a manner as the President may order. So any judgment that has been rendered by the Supreme Court that need to be implemented as per the, under Article 142(1) of the Constitution.
Then what is the role of the Parliament then?
I am coming to that. I am Deputy Speaker, sir. I am coming to that. I am coming to that. Of course, role of the Parliament. I do consider because there was a fiery speech as far as NJC is concerned. I don't want to clarify much about NJC because the final verdict has not yet come. Because, of course, on 16th October, the collegium system has been restored and the 99 constitutional amendment was struck down. But afterwards, the court...
Law Minister, that is not the point. What Prem Chindan raised, the Parliament has the power, that is we are enacting, discussing.
Yes.
When the Supreme Court says that term and everything, it has to be like that.
Yeah.
They can dictate it. Why we have to bring and discuss it?
No, sir.
That is the point what other members are raising. Therefore, that whatever you are quoting, the thing that may not be, that is what I am feeling.
I will tell you.
Therefore, we cannot defend, Parliament cannot defend taking the Constitution as we have to obey the Supreme Court thing. That is the provision you are quoting. That is some kind of misleading the House. What I am feeling.
Deputy Speaker, sir, not only just because of the judgment, just because of Article 142, why the Parliament should not override that judgments and we can't draft a law. That is the question placed by. But as far as
civil throughout the territory of India,
yes,
in such manner as may be prescribed by or under any law made by Parliament.
Yes, that is for that reason
that's what we have read. So as made by Parliament will be the ultimate end.
Sir,
ultimate truth.
Unless and until that has been enacted as a law by the Parliament, it cannot be enforced. Now, the judgment has come. Sir, I would like to... 42.
I think the Honourable Law Minister, when he presented here, he seemed to give an impression that whatever the order or decree made by the Supreme Court is enforceable until the law of the Parliament is made. No, you have not told me. You have just said, we are bound to implement it. No, not at all. You are always entitled to bring a law, and either you can enforce it or you may make a contrary law. That is the clear version. This has been interpreted number of times. I think My suggestion to the honourable member is on this, I think your stand may not be correct. Better you consult the Attorney General or the Law Ministry. No, I am telling you. You know, my suggestion.
Yes,
of course, but your Law Minister's statement going on record in the Parliament, saying that whatever the order made by the Parliament is enforceable under Article 142, notwithstanding any law passed in the Parliament, is not correct. Not correct. It's not at all correct. Let it not go. You can just go through that. I have also handled this portfolio.
I just read.
I have handled this portfolio both in the state and here.
Yes.
I am telling you, a number of things have come. Then, you remember, in that one case on the medical seats and also the other seats on the common entrance test, matter came up. Then the Supreme Court passed an order. Then it was opined by then Attorney General and also by the various courts that we have to bring out a law to annul that. So the law has to be brought in. I don't think in the absence of the law, 142 cannot say it is absolute. It cannot be absolute, subject to the law made by the Parliament.
Sir, it's absolutely clear under the Constitution that the law has to be made in Parliament and the country has to. No, he was trying to explain it and said that there was an observation by the Supreme Court. Till the time the Parliament frames a law, we are under a certain constraint. So this is what he was trying to explain, and let him complete and we'll have the discussion.
Deputy Speaker, sir, 1 minute. Deputy Speaker, sir, of course, the directions of the Supreme Court that has been brought as a bill before the Parliament. I'm just explaining the reasons how it could be justified. Of course, the judgment of the Supreme Court in this direction, how it could be justified and why I brought the bill. That is what I am telling. I read the relevant portion of the article. That's all. I have not gone beyond that. I never said that it is mandatory for the Parliament to obey the judgments. Parliament is supreme. I don't dispute that.
That is what the members.
Sir, practically, Deputy Speaker, sir, a similar provision was there. It was made available for the Supreme Court judges in the year 2005. Similar provision. And even afterwards also, it is after detailed review and other things, it came to our knowledge that there is some discrimination. Now, for example, an advocate from any court, he will be elevated as a judge to the High Court. Usually, in between at the age of 50 to 55 years. Because till then he becomes expertise in his fields and all that, afterwards he will be taken. Ultimately, for getting a pension, he has to complete 14 years of service, that's the rule. So if it is 52, 54, he is going to retire at the age of 62, then he will not get the full pensionary benefits. And usually an advocate who has got a good practice, who has set up his office for over 10, 20, 25 years, he never used to be elevated at never used to prepare to be elevated as a judge to the High Court. So, just to give some incentive and see that there should not be any discrimination at the his retirement stage, it should not be the case. For that reason, this bill has been brought. Another thing is, very important thing is that even an advocate who retires after becoming the judge at the age of 62, he can't relocate himself because he can't practice in that High Court. He has to shift it over somewhere else, and once the lost practice, he may not able to get. So there will be a grave injustice to the advocate who is elevated as a judge from the bar. And usual practice is 2/3 the judges will be appointed from the bar. 1/3 judges will be appointed by the judiciary. So totally, at present, there are huge vacancies because at present nearly 400 High Court judges posts are vacant. So all 1/3 means nearly 300 persons has to be elevated from the judicial, from the bar to the bench. So automatically, whenever they see that even after 62 years of age, if they retire, if they don't get anything, automatically they feel somewhat it is not very favorable for us to be there in the judge post. So all these, considering all these things, to get this feeling in the advocates fraternity. This we wanted to bring this bill before this. Of course, judgment is there. Judgment is one of the areas. It is only an advisory for us to draft this bill. So, on the basis of all those things, we have brought this bill. And not only this area, even other areas also we have covered with regard to the leave and other things. There were several anomalies. Earlier, the civil servants were used to be appointed as judges. Now it is not there. Earlier, Indian High Court were there in Rangoon and other areas. So that Indian High Court judges were given salaries under this. So all these areas, we wanted to consolidate, and all this redundant and outdated laws that need to be rectified. For that reason, we have brought this bill. So there are reasons, not only just because of the Supreme Court judgment is there, we are following blindly. No, it is just like an advisory. We have taken note of the certain things which are observed by the Supreme Court judgment also. So we are going ahead with this, sir.
Just a minute. Minister, just a minute. Now is going to be 6 o'clock. The House agrees we can extend till the minister's reply. That is.
Sir, the other areas.
Move. One more bill to move. That is. No, after finishing, let him finish. Let him finish.
Sir, as far as the NJS is concerned, as for the because I will not be able to answer because the final verdict has not come out of the Supreme Court. Still, they sought some suggestions, and of course, we have received certain suggestions, and certain suggestions are given to the Supreme Court. So, till the outcome of the Supreme Court's verdict, we are not in a position to debate that issue. But what they said, there are certain deficiencies in the collegium system. So you give your suggestions, we will get it rectified. It is a continuation. It is a continuation of the earlier judgment. Out of that judgment only it has come, sir. So out of that judgment, it might have struck down. They might have struck down the NJC. They might have struck down the NJC. But the subsequent, they have continued the same bench to hear some more things, some more suggestions from various corners, stakeholders. So no, unless and until the final verdict comes from the Supreme Court, I am not in a position to debate on this issue.
Okay.
The other few questions asked by our friends with regard to the establishment of the Supreme Court benches and High Court benches in the various parts of our country. Especially Article 130 is very clear as far as that matter is concerned. Unless it is concurred by the Chief Justice of India, at the present Act doesn't permit us to go ahead. We can't establish a Supreme Court bench somewhere in any parts of our country unless the Chief Justice of the Supreme Court concurs.
There is no proposal with the government.
There is no role of the government at this stage. So at this stage it will not be possible.
This is suggestion. Only member suggestion. The suggestions they are giving. Suggestions they are giving when High Court benches are there.
That is well taken.
When if you take Chennai, Madurai is having a High Court bench. So like that, they are asking Supreme Court bench must their suggestion.
Deputy Speaker, sir, all the suggestions are well taken. That is what I said in the initial stage itself. So there are various demands from various corners of the country for establishment of the Supreme Court bench as well as High Court benches also. But both things, even for High Court, the state government with concurrence of the Chief Justice of the concerned High Court, they have to move the papers. No such proposals have come from any of the states so far. Neither the Chief Justice nor the Chief Minister has concurred, and they have come up before us to have a bench of the High Court anywhere. As far as one more important issue that has been raised,
Kerala for the establishment of a High Court bench in Thiruvananthapuram. Unanimously, the Legislative Assembly of Kerala, it has passed a resolution that has been given to your predecessor also.
Sir.
And even now, there was a private member's bill.
No, sir.
Right.
Sir. any resolution by the legislature itself will not be sufficient. Any movement by the government will not be sufficient. It should be concurred by the concerned Chief Justice of the High Court also. No, it is not correct. Okay. The Chief Justice and the Chief Minister, they both should concur the proposal and they should send it to the central government. Then only we can go ahead with the. So far, no such proposals are pending before us. But there are so many requests. But there are so many requests from various corners, from various states. Several MPs have placed their demand before us. Several Chief Ministers have sent us, but there is no concurrence from the concerned Chief Justice of the state, the High Court. So, at present, unless it is concurred, we are not in a position to go ahead. As far as salaries are concerned, why as higher salary should be given to the judges? That was the question that has been raised by all the members. Usually, the Chief Justice of the High Court and the Chief Justice of the Supreme Court and that of the High Court and others, their salaries are on par with the salaries of the Cabinet Secretary and other secretaries of the, as per the civil service. As soon as the pay commission revives, automatically the salaries of the Supreme Court judges and Chief Justice also goes like that only. At present, the Chief Justice of Supreme Court gets 1 lakh rupees per month, and Chief Justice of High Court gets 90,000. These are that is on par with the Law Commission's report. Salary, yes. As far as salary is concerned, I think that the 7th Pay Commission has already submitted the report to the government, and the government had to finalize the things. It has been recommended nearly 2.25 lakh to the secretary to the government and 2.5 lakh to the cabinet secretary as per the 7th Pay Commission. So automatically the salaries of the judges, almost all the members were telling that their salary should be enhanced. There is no dispute as far as that matter is concerned. I hope that it will be there. And Mr. Prem Chandran said that the leave allowances and other things, that's also really now, as per this bill, it will go beyond the payments that are being made to the civil service servants. But it is not like that. Even earlier, in the earlier act, the judges' salaries and their pensions and other things are concerned, that they didn't have this earned leave. They had only this half leave allowances and other allowances. So we have consolidated everything and brought a comprehensive leave benefits to the judges. Yes. So as far as other matters are concerned, there is no serious concern by my learned colleagues. Only thing is, it was said that the total, there are certain grievances against the judiciary, and it is visible by the arguments placed by our learned members across the. Of course, there need to be some more reforms as far as total set of judicial reforms are concerned. Certainly, we are working on this. I am taking all the suggestions of my learned friends, which has been given in Parliament, and certainly we will look into the matter how we should go ahead with this. With these words, I seek that the bill may kindly be passed.
Lot of people, lot of Sikhs, 3,000 Sikhs in New Delhi and 8,000 more in 40 cities throughout India were massacred. The cries of the family members and their mourning can still be heard. But these lives got lost in the midst of time.